Good evening. I'm going to go ahead and get us started in here tonight. It is my great pleasure to welcome all of you here this evening for the 8th Annual Judge Stephanie Seymour Distinguished Lecture in Law. I'm Lynn Ensroth. I'm the Dean of the University of Tulsa College of Law, and it's a true pleasure to host Marin Levy. Did I get that right this time? Closer. From Duke University to present our lecture on important and timely issues in judicial administration and the legal process. The Judge Seymour Lecture in Law program was established by Judge Seymour's former law clerks to recognize and honor the judge. This is the only lecture series in the nation established by law clerks to honor the judge they served. The lecture series reflects not only the deep admiration and affection that Judge Seymour's clerks held for her and still hold for her, but also it reflects the lifelong importance of mentorship and particularly the mentorship relationship between a judge and her law clerks. The working relationship between a judge and her clerks is incredibly important in establishing and launching talented young attorneys on their legal careers. Among Judge Seymour's former clerks is our former dean, Janet Levitt, who credits Judge Seymour and her red pen with enhancing, honing, and developing her analytical skills, her writing skills, and helping her find her legal voice. But Judge Seymour did far more than just wield her red pen. She instilled in her clerks the ability and sense of responsibility to treat all individuals with respect and dignity, remembering that the rule of law is a worthy and important value that applies equally to all who come before the court. In keeping with the values and importance of mentorship and the support of those in the early stages of their career, the Seymour Lecture Series sponsored untenured faculty who are establishing their voice and role in legal scholarship and academia. And today we welcome our 8th lecturer, Professor Levy, to talk with you this evening. Professor Levy has an exceptional background in academic training and experience. She earned her JD from Yale Law School, where she served as editor-in-chief of the Yale Law and Policy Review. She earned her master's in history and philosophy of science and medicine and a bachelor's degree in ethics, politics, and English at Yale College, where she graduated cum laude in both majors. Professor Levy practiced law in Washington, D.C. with the law firm of Jenner and Block, and she served as a law clerk in the Second Circuit. In 2009, she joined the faculty of Duke University School of Law, and her academic interests focus on civil procedure, judicial administration, remedies, and federal court. She has published or has worked forthcoming in the Yale Law Journal, the University of Chicago Law Review, the Cornell Law Review, and the Duke Law Journal. This evening, Professor Levy will be presenting her talk entitled Judicial Administration and the New Legal Process, in which she turns scholarly attention and focus on judicial administration and the importance of how courts function. Please join me in welcoming Professor Levy.
Thank you so much for that introduction, and thank you, of course, to Judge Seymour, to the University of Tulsa College of Law for having me speak here today. I spend my time researching and writing about the federal judiciary, so it's a particularly meaningful honor to get to be here and speaking before one of the greatest judges who's been on the federal bench, so thank you very much. And finally, thank you to the rest of you for coming today. I have to confess, if I had seen that there was a lecture that was being delivered on judicial administration and the new legal process, well, first of all, I wouldn't have had the faintest idea what it was going to be about. And second, if I had to guess, I would think, well, this is going to be really boring, whatever it is. So you're incredibly kind of given me the benefit of the doubt and come here tonight, so thank you so much. So let me begin first by telling you a little bit about what the talk is going to be about. And in the hopes of making it not so boring, let me do so by way of telling a story. So more years ago now than I would like to admit, I was lucky enough to have the best job that exists. I was a law clerk to a great judge. And as anyone here who's clerked knows, the first few weeks of that job are spent at the very start of a very steep learning curve. So we quickly, not always gracefully, learned the rhythms of an appellate court, right? We began to appreciate which stacks of paper corresponded to the sittings that had just happened, which stacks were reserved for the sittings that were about to come. And just when we thought we were getting the hang of it all, I found in chambers a stack of papers that was as yet unidentified, and I began to panic. What is this? Oh, God. So when I inquired about this set of briefs that had just come into chambers, I was told, well, don't worry about that. Right? Those are for the non-argument calendar, so you clerks don't need to worry. I was so relieved. Oh, great, that's just for the non-argument calendar. After about a minute, I then said, well, what's a non-argument calendar exactly? So despite having spent 3 years in law school and a year in private practice, I had no idea that some, much less the vast majority of cases, they're decided on the merits in the federal courts, go without oral argument. This was news to me, so this then led me to ask quite a few questions. So when exactly did this non-argument calendar start, and why? Cases get placed on the non-argument calendar. Who decides which cases are placed on the non-argument calendar? And how does our circuit's way of handling these cases differ from the way that other circuits handle these cases? Now, over the course of that year spent clerking, we were fortunate enough to have lunches with other judges. And these judges were patient enough to answer my very tedious questions. So, well, I was told the non-argument calendar started sometime after September 11th. It was designed mostly to handle immigration cases. And, well, the circuit decides which cases will be placed on it, again, namely immigration cases, but any judge can move those cases, one at a time to the argument calendar, and so on and so forth. But what was most surprising to me was the answer to that last question. Almost nobody I spoke to knew about the case management practices of the other circuits. And this really seems so surprising, right? It seems like such an important issue. Well, which cases are going to get oral argument, which ones aren't? And as a related matter, which ones are going to get published opinion and which ones won't. And more broadly, just figuring out how cases get managed as they move through the federal court system. So I found it astonishing that none of the judges that I spoke to were familiar with the practices of the other circuits. And stepping back, I thought it was pretty amazing that this was a topic that was virtually untaught in law schools. So as a result, I quickly realized what it was that I wanted to research and write about. When I began in academia and started down this path, I was heartened to learn that this area of study has a name to it. My judge is very big on titles. He says you have to care a lot about the title. So I thought, oh, this is great. This area of study has a title, and it's called Judicial Administration. I thought, well, what could sound more important than that, right? The administration of justice. And yet, this lofty idea I had was soon punctured. So I was speaking to a distinguished member of the academy who asked me what I worked on. And I said, quite proudly, judicial administration. He said, oh, no. Sort of in hushed tones, like, don't let that get out. He said, you can't say that you work on judicial administration. So first of all, it's really boring, right? So it's going to put people to sleep. But more importantly, he said, it isn't sufficiently theoretical. He said, serious academics are not going to take you seriously if this is what you work on. So luckily, he offered a solution. He said, well, we need to call it something else. And he thought for a minute, thinking. He said, I know what we can say. We can say that your work is part of the new legal process. So I wasn't sure exactly what this meant, as I wasn't sure that I even fully understood what the old legal process really was about. But I figured I had better accept his bid. If one needs a Trojan horse to discuss this work, then so be it, and let the new legal process be that Trojan horse. Because whatever one calls this field, whether we call it judicial administration, the new legal process, court studies, or even federal courts, my claim is still the same. This is a hugely important area, one that I believe is understudied both in law schools and by law professors. We devote much of our time to studying the substantive law that the courts decide: constitutional law, intellectual property, employment law, administrative law, and so on and so forth. And we study the procedure of these courts, both civil and criminal. but we actually spend relatively little time studying the courts themselves. For example, as compared to the theory of the First Amendment, with all due respect to any First Amendment scholars sitting here, there has been minimal ink spilled trying to answer the following questions. Well, how exactly do the federal courts of appeals function day to day? How do they manage the thousands of cases that are filed each year? How do the courts decide which cases will go to mediation, and how are those mediation programs run? How do the courts decide which cases will go to argument, and how are those oral argument panels formed? For cases that are decided solely on the briefs, how do the judges deliberate and reach their decisions? And how do the courts decide which cases will be decided by published opinion and which by unpublished order? Now, despite how little attention these questions have received, as I said, I think it's fundamentally important to study how our federal courts operate. To borrow a phrase from Professor Judith Resnick, what can seem like mere housekeeping practices can affect not only the outcomes of cases, but also the perceived and indeed true legitimacy of our institutions. So to support my thesis that we should devote more resources to this area of study, let me provide two case studies, as it were, beginning with case management and then turning to case practices more generally. So as I mentioned a few minutes ago, I was surprised to learn, that when I was first clerking, that the majority of cases on appeal are decided without oral argument and result in unpublished opinions. So by contrast, my sense from law school was that every case got oral argument. You had these three judges, they were very solemn, they heard these cases, they then went back to deliberate, they conferenced around a big table, often made of oak in my mind, right? After this, they all adjourned, went back to their respective chambers. One judge typically looked like Learned Hand with the bushy eyebrows and everything, right? They're kind of ruminating. He would be the one to write the opinion. Sure, maybe you'd have a little help from an elbow clerk, right? And then that opinion was, of course, destined for the pages of the Federal Reporter. This is what I thought happened in the real world, okay? What I did not learn in law school, but soon learned while clerking, is, as Judge Clifford Wallace once said, an appellate court must begin managing the life of a case the moment it arrives at the courthouse. Now, I'm sure the majority of you here know much more than I certainly did, but let me just fill in a little bit of this. So to briefly sketch the arc of a case in the Court of Appeals. So after it is filed, in most circuits, a decision is then made about whether it will presumptively go onto an argument calendar, or if it's going to be set for decision on the briefs and the record below. Now, in different circuits, this decision is made quite differently. So some circuits have a default rule about which cases will be set for non-argument. As I mentioned earlier, the circuit where I clerked primarily has immigration cases going to the non-argument calendar, but for a time they had sentencing-only cases going there too. In other circuits, the decision is made case by case, with either a judge or a staff attorney providing that screening function. And different considerations might come into play when you're determining if a case should be argued, right? You're thinking about how novel the issue is, how complex it is, how big the record is below, if the person who's bringing it is bringing it pro se, so on and so forth. Now, the cases that are argued then follow what we think of as that traditional model with Learned Hand in the background, right? The judges then, of course, tend to conference, then they determine who's going to write the disposition, and so on and so forth. Now, depending on the circuit, some or all of these cases will result in a published opinion. So, for example, the First Circuit publishes almost all of the opinions from cases that they have argued. In the Second Circuit, it's actually a much lower percentage. And I shouldn't do this, but why not? So one of my favorite stories comes from a judge on the Second Circuit who accepted an offer to visit the First Circuit when they had a sitting down in Puerto Rico. It was February in New York, and he wanted to get out of there. So he thought, what could be better than, leaving New York in February, going down to Puerto Rico? Well, he didn't know about this practice in the First Circuit. So he said, I went down there thinking I was going to walk out with, an opinion or two. He said, my God, I had so much work. It's more work than I've had with 3 or 4 of my own sittings combined. What a vacation it was. Poor man. So turning back now to the cases that are decided solely on the briefs, depending on the circuits, staff attorneys may assist in handling those cases, either providing a memo on the merits or sometimes even a draft order. and the judges then vote. So in some circuits, it happens that they deliberate in person or perhaps by phone. In other circuits, the judges review the materials on their own, and then they fill out voting sheets that are either circulated to their colleagues, round-robin style, or they might just be sent directly to the presiding judge. And ultimately, almost all of those times, those dispositions are what we call unpublished, which really today, of course, as you all know, is a term of art. They're by and large available on things like Westlaw, but they're just not published in the Federal Reporter. And most importantly, they don't result for us in binding precedent, though they can be cited for persuasive authority. So as I began clerking, this entire case management system was news to me. It was apparently news to others too. It was just earlier this year that the New York Times published an expose about unpublished opinions. My God, the horrors, right? So the article led off with the following statistic that we get from the FJC, the Federal Judicial Center. So in the 12-month period ending September 30th, 2013, 88% of all appeals decided on the merits had resulted in an unpublished opinion or order, rather than a full-length published opinion. The article then noted the key features that distinguish unpublished opinions from traditional opinions, that they are generally much shorter, and as we have discussed, that they have no precedential effect. And the focus of the Times article was precisely on this last point, that unpublished opinions of the federal appellate courts are not binding, and the suggestion of the article was that this feature was being used by judges strategically. So the article quoted a recent dissent from a denial of certiorari by Justice Thomas in a case coming out of the Fourth Circuit on the presumption of judicial vindictiveness that applies when a judge imposes a more severe sentence upon a defendant after a new trial. So the decision from the Fourth Circuit was unpublished, but given that it was nearly 40 pages in length and, according to the justice, created a new rule within the circuit, he argued that it should have been a published opinion. Indeed, Justice Thomas then went on to conclude that, quote, "It is hard to imagine a reason that the Court of Appeals would not have published this opinion except to avoid creating binding law for the circuit." The New York Times then went on to quote a few other justices and several law professors to support the proposition that the strategic use of unpublished opinions might be a problem extending beyond this particular case, and that the use of unpublished opinions was problematic generally. Now, if I were a judge on the Court of Appeals, this type of article would have driven me mad. So yes, of course, it's true that the vast majority of cases decided in the Courts of Appeals are decided by unpublished opinion. But what the article devoted very little space to is the fact that there are, of course, good reasons why the courts have unpublished opinions, and indeed why the courts have case management practices more generally. And again, because I'm doing my best not to bore everyone too much, I'm going to limit myself just to two of these reasons. So first, as Judge Seymour wrote in an article on the judicial appointments process in the Tulsa Law Review, quote, "The enormous caseload of the federal courts of appeals looms large." During the 12-month period ending on March 31st, 2014, there were just over 55,000 cases commenced in the federal courts of appeals, excluding the Federal Circuit. That works out to just under 330 cases per active judgeship per year. So imagine for a moment writing 330 full-length opinions each year, in addition to holding oral argument, and perhaps needing to travel to do so, in addition to handling motions, in addition to performing committee work and judging moot courts and giving speeches and doing the numerous other jobs that we ask our judges to do. And I'm sure Judge Seymour could fill out that list a lot beyond what I've even come up with. Right? So there's a reason why we envision learned hand being able to hear each case, to give it careful attention and to craft a thoughtful opinion. In 1950, when Judge Hand was on the bench, the average number of cases per active judgeship was about 70 per year, or about 1/5 of what it is today. So when one is faced with an enormous caseload, it simply isn't possible to give each case the quote-unquote learned hand treatment. Now, judges have often reported that writing full-length precedential opinions is the most time-consuming aspect of their job, with some studies suggesting that opinion writing comprises over half of judges' working hours. So it should come as no surprise then that as the caseload has increased over years, judges have found the need to use shorter and faster to execute forms of deciding cases. Now second, even if judges today did have the time of judge hand, it's not clear that hearing argument and then publishing an opinion in every case would be desirable. And while there are thousands of novel important cases that come to the courts each year, there are also cases that raise questions that have already been asked and answered. Here are a few of my favorite examples. The so-called tax protester appeals, in which the appellant challenges a conviction for tax evasion based on the argument that the federal income tax is unconstitutional. Sadly, not a winning argument. Cases in which the appellant claims that his conviction violates the indictment clause of the Fifth Amendment because only capital letters and not both capital and lowercase letters were used to spell his name in the indictment. I have seen this case. And cases in which the appellant argues that he should be able to sue a private attorney for malpractice under 42 U.S.C. Section 1983. Now, I may not know much, but even I know that these are cases that do not need to be argued in the federal courts, and that having opinions in the Federal Reporter to discuss their merits, particularly when these are the second or third or 10th attempt at them, these things aren't helping the system. So as I said, if I had been a judge reading a news article suggesting that we eliminate unpublished opinions, I would have been driven mad. Now, as it turns out, as a law professor, it drove me mad as well. So in the days that followed the publication of this article, there was much buzz on the civil procedure listserv. If you are not on it, I tell you, do not join it. It's a collection of law professors. We all teach and write in this area. We get pretty worked up every now and then, and we got pretty worked up then. So much of the discussion, again, focused on the negative aspects of unpublished opinions. Isn't it problematic that they exist? With very little sense of why these opinions and case management more generally has become a necessity in the courts of appeals. Now, Judge Posner, in his forthcoming book, Divergent Paths, and I always hesitate to say forthcoming when I'm talking about Judge Posner, because in the time between I wrote those words and I'm saying them now, you know he has that book and another one on the shelves already. But let's say forthcoming. I think it's still a few more weeks until it comes out. So Judge Posner, in this new book, makes the point that the legal academy could be doing far more to help the federal judiciary. And this dovetails with my claim, which I will now endeavor to make. So the case management practices of the federal courts comprise a hugely important constellation of issues, right? Whether a case receives argument, whether it doesn't, whether it results in a published opinion, whether it results in an unpublished order, we think that these differences matter overall. And I believe if the Academy devoted more resources to studying these practices, we would see that there's little utility in simply criticizing the very fact that they exist. Indeed, if we devoted more resources to studying these practices, we would see that there are important questions about case management that we could perhaps even be some help in answering. Let me briefly suggest three. So first, as I sketched for you, there's often a decision made at the outset of an appeals trajectory. Will it receive oral argument or not? With the understanding that cases that do not receive oral argument will often then be worked up by staff attorneys and will result in an unpublished opinion. So again, the fact that such a case management system exists makes sense. The critical question, though, is do we have the best mechanism in place for deciding which cases are going to receive what kind of treatment? Now, as I mentioned, different circuits have different practices when it comes to sorting cases. Some rely on rules about cases, and others rely on standards, with either the judges or staff attorneys applying the standards. It would be useful for academics to study these different methods more closely. For example, what are the costs and benefits of these different systems? To pick up on the traditional rules standards debate, it seems that the circuits with default rules will likely have a more efficient system. And yet, on the standard side, we might think that a case-by-case approach will lead to a more desirable result, a benefit that, of course, could be worth that cost in time. Now, part of this analysis depends on whose time we are discussing. Should a staff attorney or a judge be the first decision maker when it comes to sorting cases? And part of this analysis also depends on what checks are in place later in the timeline of an appeal. Once a case has been set to be decided on submission, is it only the judges who may move a case to the argument calendar, or may the staff attorneys do so as well? In short, there is useful work that could be done to better understand the mechanisms by which the different courts decide which cases will receive which treatment. Now, second, as I mentioned, most of the cases that are decided after submissions on the briefs receive some treatment by staff attorneys. Either a staff attorney writes a memorandum recommending a particular judgment, or in some cases a staff attorney will actually present a panel with a draft order for the case. Now again, to the extent that academics have studied these practices, they have been largely critical of them. But what we have missed is that we could help to determine whether there are gains that could be made in the system. So as it turns out, the circuits have really different staff attorney offices. So some have attorneys who serve for a single term, like a traditional clerkship, whereas others favor a career model. We actually have staff attorneys who come on and that's going to be their career for a long period of time. Some have clerks who specialize in particular areas, whereas others hire only generalists. And this would be a really rich area of study from an institutional design perspective. Well, which systems seem to work better? Is it preferable to have attorneys develop an expertise, particularly when we may be talking about a complex area of law, such as immigration? Or, as judges have argued about their own job, is it preferable to maintain a mix of cases to keep the work particularly engaging? Again, there are important questions about how to run the offices of the attorneys who are assisting the judges make decisions in tens of thousands of cases each year, and academics could make a contribution by helping to answer them. And for a final example, as I mentioned, the circuits differ in how they vote when it comes to these non-argument cases. So in some circuits, the judges come together and they deliberate, either in person or by phone. But in other circuits, the judges review the materials by themselves, and then they vote on a voting sheet. And as I said, in different circuits, there are different practices regarding how voting should take place. So in some circuits, a kind of round-robin model is favored. What this means is that Judge A votes, and then Judge B gets the voting sheet, and then necessarily knows how Judge A has voted. Right? And then when Judge C casts her vote, she knows how Judges A and B have already voted. In other circuits, by contrast, the votes are transmitted directly to the presiding judge, who may not even get to see the results herself, so that no judge ends up being influenced by the other panel members' decisions. So it would be valuable to know more about these different deliberation methods and these voting practices. Why have the courts developed these different models? With voting procedures, is there a valid concern about creating path dependence with non-argument cases in a way that maybe we're not concerned when you actually have voting all together around a table? Once again, what are the costs and benefits of these different practices? Now, hopefully, these three examples persuade you that there's a great deal of work to be done examining the various case management practices of the circuit courts. Part of what is wonderful about the circuits and what makes them such a joy to study is their variation. To borrow liberally from Justice Brandeis for a moment, it's as if each circuit is a laboratory of case management experimentation. But of course, a laboratory's experiments are most useful when those results are shared. Now, it's difficult to ask judges themselves to undertake the work of comparing practices and evaluating the strengths and weaknesses of each. When I asked judges why they didn't know more about the practices of other circuits in interviews, the consistent answer that I got was that they were far too busy for this, right? A point borne out in the caseload discussion that we just had earlier. But this is precisely the kind of work that academics can do and should be doing for the federal courts. So stepping back, I think that there's a larger point here as well, and you'll have to check me on this. When I teach, I always talk about stepping back, and I'm worried in this lecture, if you don't stop me, I'll be stepping back so much, I'll say I'm in Oklahoma City by the time I'm done. But again, if you permit me just to step back a moment, I do think that there is a larger point here. So I highlighted the differences between the case management practices of the circuits, and it's important to know that there are actual differences in, say, the oral argument rates and the publication rates as well. For example, in the DC Circuit, we see that they publish 46% of their opinions in cases decided on the merits, whereas in the Third and Fourth Circuits, we see a publication rate of about 6%. And that's all I'm going to do with statistics. We're not going to get even more boring than that. So part of the difference, of course, in these rates is differences in dockets, both the number and type of case that each circuit receives. Right? So, of course, the DC Circuit has the lowest number of cases per judge, And a very high percentage of those cases are complex administrative law cases that raise novel issues, right? So as such, they have both the time and the need to publish a greater percentage of opinions. But the larger, and I would say much more interesting point here, has to do with the culture of the different courts. So one circuit in particular, the judges I've interviewed on that circuit, talk about how that circuit has a long-standing tradition of valuing oral argument. They say oral argument is really important in our circuit. And as a result, they prioritize having cases go to oral argument, even at the expense of other things. Talk to judges of a different circuit. They have a very different view of oral argument. They say, we think this is a real cost that we're putting on lawyers and parties, making them travel several states to come see us. So their view is we should only have oral argument when it's really necessary. By contrast, that circuit really values having a low median disposition time. They like to get their opinions out fast. They think this is really important for the parties. Right? Really interesting. You have two circuits. They're not even that far apart geographically, and they just have a very different sense of what's important as part of their role. So I think what's so interesting is thinking about these different case management practices, where they come from, right? There are important questions here about why these circuits have such varied norms, and to what extent these differences in culture actually justify differences in court practice. Academics could do more to help the courts by studying these issues and trying to provide answers to these rich and, dare I say, even theoretical questions. Now, the first case study that I provided concerned the case management practices of the federal courts of appeals. So the second case study that I'll give you more briefly shifts to court practices more generally. So I'm just going to quickly think about the formation of oral argument panels. So when I was first learning about the case management practices of the different courts of appeals, I conducted interviews of judges. And in those interviews, I always asked as my last question, is there anything that we academics could study that would be useful to you? So part of this, a la Judge Posner, was an attempt to make sure that the work we were doing was actually being useful. And part of it is, it's hard to write a research agenda, and so if you can consult with an article free, well, why not? Of course. So I'll never forget when one judge responded to this question. He said, oh, I would study the way that oral argument panels are formed. The 3 judges they pick to hear cases. I'd look at that. Specifically, he said he'd been concerned that in his circuit he was seeing a lot of repeating panels, meaning that judges A, B, and C were sitting together a whole lot throughout the year. And this concerned him. He thought it'd be useful to look into that, what was going on in the other courts. So stepping back, despite my time, again, in law school and in private practice, and even clerking, it hadn't occurred to me that the oral argument panels of the federal courts were not randomly configured. I thought panels were formed just by picking names out of a hat, and so on and so forth. Well, I soon learned that this is not the case, right? So as it turns out, there's no rule that tells courts how they're supposed to put their panels together. The area is technically governed by statute, but the relevant code states only that the panels must consist of 3 judges, and the panels shall sit at the times and places as the courts direct. So accordingly, that means it falls on the circuits to not just put their panels together, but to determine how they're going to put their panels together. So to understand a little bit better how it is that the Court of Appeals take up this task, I conducted a lengthy qualitative project. I interviewed just over 40 judges and clerks of court, and I focused on 5 circuit courts. And I think the results are pretty interesting. So for one thing, the circuits that I studied have very different ways of forming panels. So some leave the matter up to the clerk of court or the circuit executive. For some, this is all within the domain of the chief judge. For another thing, none of the circuits use what one might call a quote-unquote perfectly random process, say by picking names out of a hat. There are in fact quite a few ways in which the courts depart from randomness, and I'm just going to sketch out a few of them quite briefly here. So first, I think not surprisingly, a lot of courts depart from randomness for logistical reasons, right? So you might have a judge who's going to be out of town 1 month, or another judge who has a teaching commitment 1 semester. Right, so the courts that don't have a designated court week, that is a week where everybody comes together to hear cases, right, they tend to depart from randomness by accommodating the schedules of different judges. Second, there are of course departures from randomness for efficiency reasons. Right, so you might have a panel that hears a particular case, they remand it to the district court, comes back on appeal, And the thought is, well, wouldn't it make sense to bring that first panel back together again to hear that case? Or at least one or two members if we can, right? And that then might end up affecting how the panels are formed for the rest of that term. But outside of these standard logistical and efficiency-based reasons, there are other reasons for departing from randomness that are harder to categorize, but I think actually even more interesting. So let me just quickly mention 4. And I should say the 10th Circuit was not among the circuits I studied here, so this does not implicate anything about them. So somewhat related to efficiency, several courts that I studied have a policy whereby senior judges are allowed to request certain sitting dates. So a senior judge could say, hey, I want to sit the first few weeks in November. The rationale for a policy like this is that by providing the senior judges with their first choice of dates, the senior judges might then end up sitting for more days, which is of course a bonus for the court given the caseload as we've discussed. Second, and arguably still related to efficiency, one circuit had a policy, and I should say this was now quite a few years ago, which allowed judges to request to not sit together. So if two judges had had a particularly bad experience sitting together recently, they could say, well, let's just opt out for a little period of time. As one judge said, this was important. It gave them a kind of cooling off period, right? And the rationale was that it was going to bog down the court, right? You have two judges who are loggerheads. This isn't good for anybody, so why not just make sure they don't sit together for, say, another sitting or two. So third, and perhaps related to a different kind of efficiency, some circuits that I studied have oral arguments at different locations, say at a law school, maybe once a year. Right? And then they would select the judges for those panels based on geography. So the thought is it's easier and less expensive to have the home judges comprise the panel rather than draw from the entire pool of judges. And finally, I think this is the only one not really related to efficiency. So one circuit I studied had a very interesting policy of ensuring that every judge in their first year had the experience of presiding. Right, so of course you only get to preside if you are the most active senior member of a panel. And so on this circuit, they would take a new judge, and if after a few months that judge hadn't gotten to preside naturally, a panel would be orchestrated for that judge. So they put the judge with a senior judge, maybe a visiting judge, to round out the trio.
Something I didn't hear when it was...
And I can speak louder. And the thought here is that the judges would really benefit from having that experience of presiding, and so it was worth tinkering, say, with one panel to make sure that that would happen. So I think that these various practices once again lead to fascinating and really important questions. So are all of the reasons for creating these non-random panels really legitimate? So one can certainly make the argument in favor of them all. And yet something that I found quite interesting was that when I informed the judges I was interviewing about the practices of other circuits, not all the practices were met with approval. In fact, I'll never forget I was telling one judge about the practice of another circuit, that one where the new judges, get a special panel so that they get to preside. And the judge I spoke to was horrified. He said, "We would never do that in my circuit." Oh my. And then beyond just thinking about the practices themselves, one might also care about the consequences of these practices, how they all interact together. So let me just briefly say a word about that. So that is, it might seem perfectly reasonable that you want to accommodate the schedules of different judges. What if doing so ended up having a meaningful effect on the makeup of those panels? So suppose it just happened that the most liberal judges of a particular court took vacation, say in June, and the most conservative judges of that same court took vacation in July. Right? And let's say that as a result, you ended up having more panels with all conservative judges and all liberal judges, or something like this. Right? The question then is, what do we think about that? Well, I was interested in this question in an attempt to figure out if we were actually seeing these things in the real world. I undertook a study recently with a co-author, a guy named Adam Chilton from Chicago. We were very fortunate. We received calendar information, 5 years worth, from all 12 regional circuits. So 1 through 11 and DC. So this meant that we had the panels as they actually sat during this 5-year period. So we had over 10,000 panels in all. And based on what we knew, knowing that Judge A sat 32 times this term, 42 times the next term, and so on, we actually then had a computer randomly generate the panels of each circuit. And then we repeated that process 100,000 times. So what this meant was that ultimately we could compare the panels as they sat with the panels of a random process, a truly random process, and we could compare the two. So our analysis showed that in 4 of the courts of appeals, the ideological balance of the panels that actually sat differed in a statistically significant way from those that were randomly generated. And again, I hasten to add the 10th Circuit was not among those 4 that appeared perfectly random. But just to give you an example of what I'm talking about, so in one circuit, there were more actual panels with, say, 1 Republican-appointed judge than the expected number based on our simulations, and fewer actual panels with 2 Republican appointees than the expected number produced by our simulations. Again, this is not to suggest that there was anything kind of purposeful going on here. I think this is the confluence of all these various practices that we've been talking about. But it still leads to a really important question, which is it worth having these practices if the result is that panels have a different ideological composition than would otherwise result from a random process? I think these are difficult questions, but it's important to be asking them. And to help inform the discussion, it's important to have academics who study them. So stepping back one very last time. So judicial administration at first glance can seem like a field comprised of very small decisions. And yet, as I hope I've been able to show here tonight, these seemingly small decisions are actually quite important. They can impact case outcomes and the legitimacy of our federal courts. Returning to my esteemed colleague's point about the new legal process, we shouldn't need a Trojan horse for this kind of work. Academics should be spending more time studying it, and students should be spending more time learning about it. But just to take that Trojan horse seriously for a moment, if the great academics Henry Hart and Albert Sachs were here, I believe that they would remind us of the core values of the legal process school. They would tell us that we should devote time to studying institutions and to understanding the comparative advantages that one institution may have over another. Courts can do a great many things, but they don't always have the time to evaluate everything that they do. The academy has, as one judge once put it to me, quote unquote, the luxury of time, even if it may not feel like it. We are well equipped to study the courts if we simply devote the resources to the enterprise. And as a great judge, Judge Seymour once said, I see the role of the federal judiciary as the guarantors and dispensers of impartial justice in our system. It's time for the academy to do more for the judiciary, to help support the dispensers of impartial justice, sustain our wonderful legal system. Thank you.